So, welcome everyone to the latest edition of AI in Construction. This is a monthly webinar where I'll pull in people from various parts of the construction industry, folks that are doing things, folks that are building things. Today, I'm really honored to have with us Paul Jorgensen, who I've known now for about 3.5 years. He does IP work for a bunch of companies in our world, one of them being the Construction Specifications Institute, which is how I knew him. Paul is joining us here to talk about IP in construction. We're going to start because a lot of people don't spend their time thinking about or working with IP. We're going to go through kind of from the ground up and talk about what we're even talking about. Then we're going to explore some of the risks and opportunities that AI presents. So with that, Paul, welcome to the webinar. Let's start with what we're even talking about here. So do you mind taking a minute and talking about what intellectual property is? It looks like you're still muted. I'm sorry, I muted everyone.
Me. There we go.
Yeah, great.
There we go. Yeah, intellectual property is just like regular property. We'll start there, in that it can be owned and licensed and used and rented out and all those kinds of things. Problem is sometimes it's very difficult to touch it. So that's why it's intellectual property. Now, intellectual property is a kind of a big family. When people think about IP, they think about one type of IP usually, and it's usually the one that they know the most about. But there are a bunch of different kinds, and I'm going to go through those real kind of quickly for you. There are trade secrets, trade names, trademarks, copyrights, patents, and that's about it. Now, those are, if you can think about them, they're very distant relations. If they were a family, they would be second, third cousins. They don't necessarily come from the same place. They're not protected the same way, and they're not to be thought of the same way. So, for example, the one that you probably know the most about because you go to a store every day is a trademark. That's something that identifies a good or a service, and it protects the goodwill of that particular good or service. Now, the law in that area is all focused on consumers. So the law is real concerned that when you go down those grocery aisles, you don't get confused between this kind of soup and that kind of soup. And so that's where the focus of trademark law is. Now, trademarks are different than trade names. Trade names are the names of companies. It's usually what an entity like a IRS or something knows you as. Trade names can be the same as trademarks. Coca-Cola Company is the same as Coca-Cola, but it can be quite different too. They don't have to be the same. Trade names are not the things that a lot of consumers know you as, just things like the IRS know you as. Now, since we're in the trade world, we'll talk about trade secrets real quickly. Trade secrets, unlike trade names and trademarks, are not public. They are by definition secret, and so therefore they're not registered like trademarks or trade names. They're not disclosed. And what are they? They're anything that give you a business advantage that if somebody else had the same access, they'd get the same business advantage. So what that means is, let's say I come up with a list of vendors that I work with, and I've been developing that list for 6 or 7 years. It's very reliable. I've been taking things off that list and putting things on that list. I'm preferred with a number of those people. That's great. That's a trade secret. It's not something you're going to give away very easily or let people outside of your organization know about. So trade secrets are really important too. Now, copyrights come in a lot in construction realm. Copyrights are, yeah. Mm-hmm.
If I may, real quick, when it comes to trade secrets, isn't that one of the things that NDAs are often there for? And the reason you often will use NDAs, this isn't really an AI question, I think it's an important one. Part of why you use NDAs is to show that you value those trade secrets, not that you're going to necessarily sue someone.
Exactly, Hugh. And a lot of times you'll also see the NDA's sort of distant cousin inside of a regular contract is a confidentiality provision. And so the way trade secrets are protected are through things like NDAs, confidentiality provisions in regular contracts, and in things like employment contracts. So, for example, if I hire someone and they're going to have access to a bunch of stuff, I don't want them leaving in a week and taking all my stuff that I've put together with them. So, that's another area the way trade secrets are protected rather than through registration and the like. So, yeah, anything, formulas, lists, those kinds of things, really very important. And it might be
Well, that's
something you can do.
well, I'll just stop because that is kind
Disclose.
of relevant in today's AI world where you probably are getting someone else's patented or copyrighted model and doing things to it. And the things that you're doing to make it work aren't really something you would register, but they do constitute a trade secret because you've figured out how to make a machine
Right,
work in a way that works for construction or your system. So I just the point here is not all IP is going to be a patent or a copyright. Some
right.
of it's just going to be that you figured it out as a team. And if you're putting in place NDAs, it isn't because you think you're going to sue the signer of the NDA, although you might. It's more,
Yeah.
again, in some future litigation with someone else, you're saying this was valuable enough that we chose to protect it.
And trade secrets, by the way, Hugh, can be reverse engineered. The fact of the matter is, you and I could enter into a relationship, and after a couple of months in our relationship, maybe you figured out a way to create the same thing, the same formula that I use on a day-to-day basis, without me telling you anything about it. Maybe you just figured it out. So that's legit. You can do that. That's a legal thing. You can reverse engineer lists, formulas, and the like. So that's not necessarily protected as a trade secret if that happens. So
Got it.
yeah. So the next one is copyright. And as I was saying, copyright's used a lot in this area because there are a couple of things that a copyright is. Copyright is an idea up here that's original and creative. So it has to be those two things, but it also has to be reduced to some sort of form. In other words, you can't have a copyright in an idea. You can have one in a physical manifestation of an idea, written down, performed, recorded, any of those kinds of things. So we see copyrights coming up very importantly with respect to blueprints in construction, with respect to specifications, groups of specifications that have been creatively put together that by themselves may not be, that creative, but the way that they've been grouped together are a creative work. And so anytime those things come from the head to some sort of physical manifestation, whether it be artwork, text, computer program, choreography, any of those kinds of things, you have a copyright. Copyrights can be registered, and in a lot of cases they are registered, but copyrights exist the moment they go from your brain to the physical work. So you
Can I
have
ask,
a lot of protection.
yeah, how and what does that mean? So let's say that you're in a situation where you have, somebody who's leaving the company and they're an expert in something, and you say, hey, we're going to spend a couple hours doing a structured interview to pull as much knowledge as we can, because now we know AI can actually go access that and summarize it and do interesting things.
Mhm.
What would it take to make that copyrighted? Is it just that there's a document somewhere that says, Circle C,
Yeah. I mean,
DPR construction?
you have to be able to point to something that you have the copyright in. So, for example, let's say, let's talk about what we're doing right now. We're recording this. So the moment this presentation is finished, you will have a copyright in this presentation, in the recording. So you would point to that recording rather than the content of the recording per se. You'd point to the recording itself. This is why copyrights are so important in artistic, musical, and stuff like that areas. Also why copyrights are incredibly important and right at the forefront of AI. Because the question becomes, how can you use a copyrighted work, whether it be a recording or something written down? That becomes a very important issue.
Well, I want to take while we're here, because you're right, copyright it's also just so important in construction. Like, no, typically you don't patent the building.
Right.
There's a question from the audience. If a firm, so you're obviously familiar with master spec templates. So if
Yep.
a firm uses a master spec template, let's assume they're talking about the copyrighted one, the one from the AIA and so on, and they
Right.
change it for their use, for example, possibly to make an internal master specification or whatever, who
Mhm.
owns it at that point?
Well, that's a good question, and it really would go to whether the new work was original and creative. Okay, so let's say I just make a couple of commas and period changes. Yeah, nah, you don't really have a brand new work. Okay. There also is this concept in copyright of what's called a derivative work. And the owner of, let me back up for just a second. The owner of a copyright holds a bundle of rights. Okay. And so let's say I have a written work like master spec. I hold a bundle of copyrights to that work. What is in the bundle? Individual little sticks. Individual sticks might be, hey, this is the right to reproduce it, the right to create a derivative work from it, the right to perform it publicly. So those are some of the basic things that almost all copyrighted works have. Now, the owner can decide to keep those, to loan them out to someone, or to sell them outright to someone. That's definitely an option that you have as a copyright owner. So when someone creates a derivative work, that's practicing one of the sticks in that bundle of copyrights. And unless you have permission from the owner of the stick, you can't do that because that's performing one of the copyrights. So let's say you do, going back to your scenario, you do have a situation where you want to make some adjustments. Maybe you want to add some photographs or things like that to an underlying copyrighted work. That's a derivative work. That means that you've changed it from where it was before, and you've taken so much of the original work that you've basically created a work that's based on that. So derivative works are really one of the areas where AI turns into a big problem, is that if they are taking a significant amount or a big piece of the underlying copyrighted work and putting that into a larger work, are they creating a derivative work? A lot of people are saying yes, that is a derivative work, and therefore has to be under a specific grant or license from the copyright owner. So that's probably one of the biggest issues there. The only
And
other, yeah, go ahead.
just to that point, because there's another question about training an AI model using content that's got a copyright. There is the idea of fair use, which I
Yeah.
think has been thrown into this, and I don't know that it holds up, but I think that's part of what some of the argument is. Fair use is a carve out, right? Where you
It
have
is.
5 seconds of video, or there's things you can do. Like that's why YouTube
Yeah.
videos sometimes have very
Okay.
short snippets of like movies and so on.
It's a dangerous place to be. Okay. If you want to hang your hat on fair use, know that you just can't call it out and run away. Fair use is a very complicated analysis. Usually there are at least 4 parts to that analysis. So, and you have to think about a schoolyard with a bunch of teeter-totters in it, okay? And yes, no is where the teeter-totters are. To get fair use, to be able to claim fair use, all 4 teeter-totters, 4 levels of analysis have to be in the yes position. Okay. If even one of them is out of that position, you do not have fair use. Fair use is really difficult. Fair use, you have to say you're using a small amount of the work. Okay. That's not alone fair use. You're using it for non-commercial reasons. Okay. That means you're an academic or you're a scientist or something like that.
Or the news.
Or you're the news, exactly. You're not taking away from the market of the underlying copyrighted work. In other words, if I reproduce 3/4 of a novel, am I taking away from the underlying sale of that novel? Yeah, yeah, I am. So I wouldn't qualify there. So this is part of the analysis you have to go through. So I mean, if you're ever feeling like you want to claim fair use, make sure you talk to a lawyer about it before you just say it out loud, because it's easy to get it shot down.
And the bias in the law is not fair use. It's a carve out for special situations, is what I'm hearing.
Yeah, yeah. I mean, fair use is very unique. To be able to claim fair use, you really have to be, a government or a instructor in a college somewhere that you're using two paragraphs from existing work, and you're only using it for your students, and you're not selling it, and those kinds of things. So it's not a get out of jail free card.
And that simplifies the answer to Ted's question, which is, when you're training an AI model using copywritten data, it's this isn't new law. This is a flat out derivative use that's been around for 50 years or however long that
Yeah.
case law has been around.
Yeah, AI basically is doing something that people have always been able to do throughout time to copyright works, which is steal or use them without permission. And it's just doing it in a different way, and maybe a more efficient way, a faster way. It's really not doing much different. That said, the law is very far behind on it. I mean, it would be great to say that, oh, our legislators in state and federal government are up on this, but they're not. And that it's literally like a train leaving a station. They're to catch up with things like AI, you're running behind it.
Yeah.
And it's just not going to make it. So the law has to fall back on what it is founded on, and the IP concepts are very much there. They just have to be thought of in a new way.
If I could just talk about contract real quick. I'm sorry to keep kind of derailing, but there's some great questions that I think we might speak to.
Yeah.
So the master spec is distributed by a company called Deltek. You obviously know.
Yep.
One of their director of product in a recent event said that they'll no longer be enforcing copyright on derivative works. So that speaks to me about it's not changing the law. It's saying, first of all, I'd be a little nervous if someone says that out loud, that there's a piece of paper that doesn't say that. But it speaks to the fact that a lot of rights like this are managed in a contract, not in the law. I mean, the law sets a framework, but it's purposely general, so that you,
Right.
as somebody writing a contract, has flexibility to get done what you want to get done business wise. In the case of Deltek, my assumption is they would need to issue new licenses to people.
Yeah. Yeah. Absolutely. I mean, the thing about having the crossroads of contracts and intellectual property is constant. It keeps going back and forth, and it's very important to understand that you can protect certain intellectual properties or be forced to comply with certain intellectual property concepts at law. So in other words, someone can come after you and sue you for trademark infringement or copyright infringement based on law. Okay, great. IP law works that way too. However, if you have a license program, or you've licensed the entity that has somehow misused your copyrighted material, then you also have a claim in contract. Okay, so that's pretty good. You have two different kinds of claims. You can claim based on trademark law or in copyright law, and based on the four corners of your contract. And that's why IP contracts, or any contract in the construction area, is extremely important, because it is a physical manifestation of what two or more parties were really thinking about on the day they wrote it. And they're not around to explain it. So the courts or the arbitrator is going to look at those terms and be very literal about how they enforce those kinds of things. So yeah, it's very important. The Deltek may make all the public pronouncements they want, but if it's not reflected also in their licenses that, hey, we're going to give this away. And that's what they would be doing, by the way. If they said we're not going to enforce, if you don't enforce or police your intellectual properties, you give them away. And that's very dangerous. That's called naked licensing, and you don't want to have that happen. If you're the copyright owner, the trademark owner, or anything like that, you have to be very careful to come up with a comprehensive licensing program or sales program that makes sure that you don't give those things away accidentally. And I've seen that happen.
Well, and you lose the ability to get it back,
Oh
right?
yeah.
Like that. It really it's a bit of a one-way decision, which it's interesting.
Yeah.
Okay.
Yeah, it's you don't want to forfeit something that simply. And so that guy's public pronouncement or that person's public pronouncement, uh, uh, that's pretty scary.
Yeah. And just to put a pin in it, this is also one of the reasons why people put copyright notices all over the place. It's not to really tell you that. It's so that later they can claim and say, hey, we've been actively letting people know this is protected, this is copywritten, and so
Well,
on. So a lot of this is creating evidence for a possible later problem, correct?
yeah, and that's what you're doing in a contract as well. You are setting out the boundaries of your. I mean, think about your intellectual property as a bunch of cows in your back 40 there. You know, you're basically putting a fence around them, and you're telling people how many there are, and you're telling them that you own them, and you may be putting up a sign on the fence that says, "Hey, we own these cows. Don't if you have any questions about them, call me." And that's basically what you're doing with a copyright or a trademark notice. When you see the R, the registered trademark symbol, that means someone's gone through the registration process, got a registration for their trademark. And they're putting that notice out there because for two reasons. One is it looks kind of cool and consumers think it's great. Who knows why? But they also are putting that notice out there because then they can say, hey, we put that notice out there. They also put that copyright notice in books at the start of books and stuff. That may mean it's registered or not. It just means that the owner claims it as of that day. And again, as you said, if that becomes an issue with litigation or a dispute, you can point to the fact that you had a notice program that all your stuff had notices on it, and that in your licenses you also required that kind of notice. So yeah.
Great. I think I stopped you before you got to patents.
Oh
I'm not
yeah,
sure what
well,
was next.
patent is the kind of the distant cousin of all these things. Everybody always talks about how you should patent your grandmother's, pie recipe or something like that. That's not what patents are. Patents basically give the inventor of a new and useful invention. So it has to be new and useful. In other words, you can't just take an existing mousetrap and make it a little bit bigger. Okay, that's not new. That's just a minor variation. That's obvious that anybody could have decided to do that. So it has to be new and useful. It's an invention. And it gives that person who obtains a registration for the patent, and you have to have a registration. There's no such thing as an unregistered patent. There's a patent pending. That means somebody actually has the application in for it. But basically, it gives them a chance for a limited time to stop other people from using or selling or offering for sale that invention. Okay. So, what is the value of a patent? Well, in a lot of technical circles, it's very, very valuable because it's kind of an asset, becomes an asset of the company, and everybody knows that you have it. Universities have them, all kinds of things. Patents are valuable. But the idea of patent is that it's only going to last for a certain period of time. They're giving you that exclusivity. The government's giving you that exclusivity in exchange for the promise that after that certain period of time, this technology, this thinking will go out into the general populace. And you only get it for that period of time. So what do you really get as a patent owner? You get the ability to sue, which is great. I mean, I have a lot of clients come to me and say, "Oh, I really want to get a patent." And I'll say, "Okay, so do you want to turn into a, perpetual litigator?" And that's really what you have to do. And you hear about the big patent cases, the Apple patent cases and things like that. That's because those entities have the resources to
Yeah.
be able to do that kind of constant suing. So
And
it's
and
not it's
and
not the be all end all.
and it's expensive too. But the thing I wanted to also point out or ask you about is there was I believe it's called the Grace decision, but there was a decision that is really relevant to software, and I think especially relevant to AI, in that you can't patent. I think it's business processes. You want to talk about what that is? Because
Well,
I
a
believe
business,
in one
yeah.
fell swoop, they invalidated a bunch of software patents a bunch of years ago.
Yeah, so
But it's
they do take at least the United States does. The United States does allow for different types of patents. So you could have a bio patent, a patent that involves something that is grown or created in a laboratory. You could do one that's mechanical. You could do one that is purely ornamental patent, something that might be like the cover or the front of a particular type of automobile. And then you can do business processes. And business processes were only sort of allowed in the last half century, I suppose, in the patent realm. And basically what that means is that you came up with a not tangible process that, because it is used in it produces a particular type of result. Getting a business process patent is extremely difficult. It's really, really hard because you have to be able to show, as you do with the rest of the patents, you have to show everything that led up to the patent. So that's called prior art. And basically you have to gather everything that came up to this moment that this new invention was created. And then you have to show convincingly through a bunch of different claims that your business process is that much better or that much different than everything that's come before. So that's why. Now, were some of them invalidated? Yeah, probably some of them were invalidated because either they were obtained in an early time where people just weren't used to giving out business process patents, or they had expired, or they had become so well known that other people could not perform either the mechanical or the physical or the types of programs that otherwise they needed to do regular work. So, that's kind of why patents would have been overturned in that time. But you're right, they take a long time. They're very expensive. And once you start the process of a patent, it's here's the bottom line, folks. If you really want to do a patent, first of all, get a skilled patent attorney in your area. So if you have an electrical patent, make sure that person has an electrical degree that is in addition to their legal degree, because they're going to have to be able to translate everything that you do to the patent office. The other thing is have a lot of money and have a lot of patience, and don't use the invention publicly. Don't disclose it publicly until the application is filed. Because if you do, the application's invalid. Anything that's already out there will not be patentable.
Got it. Awesome.
Yeah.
Do we want to move and dive into derivative data a little bit?
Yes, go ahead. Absolutely.
Well, actually, that's my question to you. As we think about the types of derivative data and how the law treats these, so because one of the things in construction that comes up, and I think AI makes it just muddier, is somebody creates a thing, then somebody uses a thing, but the use of something itself creates data, which is sort of metadata. But also we're very often referencing things, but the way we reference them and the process of referencing them creates, so we've got these layers of data abstraction, for lack of a better word. And I think that, we've talked before, the best way to deal with that, at least in my view, and I'd love your thoughts, is contractually to say, we're going to be doing this, we will own that, but you retain what you had. But in the absence of that, what is it? Just pandemonium, and the biggest lawyer wins.
You're rolling the dice. Let's put it that way. Yeah, I think there have been a lot of cases out there. Let's just talk about an architectural situation where an architect owns the copyright in an original work, which might be a set of blueprints. Let's put it that way, or elevations or anything like that. And there have been claims where in a dispute, that architect, those blueprints and his ownership or her ownership of those copyrights in the blueprints have been put into question. There have even been cases where the physical manifestation of those works, the building itself, is considered a derivative work from the underlying blueprints. So without having clear definitions, and because these are all over the board and there is not a bright line rule from the courts, we fall back again to contract world, and contracts really help out a lot in terms of clarification, because even if they are somewhat counter to the case law that's out there, the courts are going to seek the comfort of good, clear contract terms. And so what you really do want to have in any sort of agreement where there's going to be, derivative works created, or where one party is going to be creating something for someone else, is you want to make sure that you have a provision in the contract that clearly states who owns what. All right. Now, why do you want to do that? First of all, if you're the service provider, you want to be able to walk away with your toolkit. If you don't, you might not be able to practice what you get to do on a day-to-day basis, and that would be bad. And I know that sounds far-fetched, but there have been cases out there where if that wasn't defined, there have been people who not only claimed the right to the work for hire, what they wanted that architect or whoever to do, but the architect's toolkit as well, and that's bad. You don't really ever want that in. So one of the things you have to define in the contract is who owns what, who brings what to the table, so you can walk away with your respective stuff, who owns what is created during the relationship for the other party, because that's not always clear. Work for hire is not always clear, and you have to make sure what is owned is very clear. And then one more, you have to make sure that you talk about who owns what is created independently from the relationship. Now, you might think that's also kind of strange, but there have been cases, again, let's go back to the architect concept. The architect's working for you, and you get in a dispute with the architect. You claim not only the stuff the architect's working on for you, but everything else the architect is working on for other clients at the same time. Now, that just sounds absolutely wacky, but the theory is, well, if you didn't have money from me, you wouldn't be working from those other people, so we have claims to their stuff too. All right? To avoid all this, contract. Just have to make sure that it's really clear in your contract who owns what, and then what happens to that stuff when the relationship ends. Is it different if the relationship ends earlier or later? If it just naturally ends as opposed to gets terminated by one or the other? All these things can be thought of. And in fact, I think anyone out there who is trying to get a contract together, these are the questions that the attorney should ask you. What are you afraid of? What are you afraid of? And one of the things I'd be afraid of is losing my stuff. I don't want to walk away from this relationship and lose my stuff. So that needs to be expressed in the agreement. And those provisions are really important. They're just as important as confidentiality. They're just as important as indemnification, all the other stuff. But yeah, ownership is huge.
And if I can just dig into this a little, because it sounds like, oh my gosh, that's a whole lot to get done. But really what you're saying is, as the business team, you're saying, okay, we keep talking about data that we need to do to, and it doesn't have to be AI, it can just be statistics. I mean, it doesn't have to be super duper complicated, but we as a contractor want to be able to aggregate information about how we execute against things, or how we work in the whatever it might be.
Right.
And I think it doesn't take a lot of time for the business team to say, like, i.e., not the lawyer, to say, what do we think we're going to want out of this? What do we think we're going to build later? The point that was brought up earlier about what happens if AI gets created with copyrighted material. I think where it runs into some trouble here is if your contract isn't clear on the fact that you can use derivative, like second order derivative data, like usage data or certain kind of high level things, which usually aren't a dispute before the work, but afterwards, there was a big hospital in New York, Sloan Kettering, came up with an amazing model they couldn't use because it's a cancer hospital. I don't need to spell out why they didn't have consent for a lot of the data they used, and It's really tough to go get that consent. but it was like 70,000 records. So they hadn't set up and thought in advance of what are we going to need. So there was no contract in place. So the point I'm making is, as a business team, it isn't intractable. It's not really hard. It's just a meeting with a whiteboard and really thinking it through, probably with your lawyer there. But I
Right.
think it's wrong to expect the lawyer to know all the right questions to ask. It's really the business team's job to say, we want to get this done in the world. Our legal counsel will help us do it well and do it and, make sure we don't get in trouble.
Well, and one of the things that if the lawyer doesn't bring it up, I mean, when we're creating agreements, we're very optimistic. I mean, it's just, let's look at the thinking here. We're really optimistic that everything's going to work out fine. Everything is going to be great. It's an important thing for everyone who's going to get into an agreement, downstream agreement with providing services or providing goods of any kind, to think through what could happen wrong, what could be all the things that they would really want to avoid. So you have to think through the doomsday stuff, and that's tough to do, especially when you're at the start of a relationship. And if the business team can think through that, that's what do they want to avoid, and a good chunk of those things that they want to avoid can be put into the agreement in one way or another. And that really helps. One other thing I think, as you were talking there, I thought it's really helpful to think of the stuff that you get to do what you do as upstream. You're standing in the middle of a river. That's upstream stuff. So the contracts that come from upstream, the sources, the representations that you're looking for, the breadth of the license. Can I use this stuff? Can I create derivative works? That will help you represent downstream to your clients what it is you can and cannot say or can and cannot do. So thinking in terms of that upstream downstream concept is really important with respect to any sort of AI or construction type contract.
Awesome. Okay, well, to keep us moving along, I'm going to talk real quick just to kind of anchor us again on what AI does with data and information. And these are rough buckets, but it's important because when you think about deep learning, it tends to take a lot of narrow data and create a classifier or a predictor, depending on who you're talking to. Basically, it does one thing a lot and quite powerfully. But the point is the data gets sort of subsumed and it isn't individually retrievable. But also, the point about deep learning is it's usually a data science team who's scrubbing the data anyway, because data in the wild usually isn't good enough. You have to clean it up and do various things. So there's a process in place to eyeball what's going into it. Obviously, you want to arm that process with legal information and legal understanding about what they're doing. But the point is there's somebody there whose job it is to look at where the data came from and how good it is and so on. In contrast, and why I think today's talk made sense to me, is generative AI gives everybody the ability to take someone else's document, doing something interesting with it, and then present it as their own, or just use it in a way that they may not even know they're doing anything bad. It's really hard to do that in deep learning, again, because there's an infrastructure standing in the way. Whereas generative AI, you can go straight on ChatGPT, upload something, do something with it, and then away you go. So understanding the IP implications of derivative work and some of the guardrails around it are important now in a way that they weren't in the earlier stages of AI. Paul, how do you think about that, and how things that companies or people might do to avoid that sort of thing? We've talked about everything from designs to specs to, there's just a lot out there that someone could transform, but but still be basing it on a copyrighted material.
Right. Well, Hugh, it always goes to, I could be the absolute doomsday person and say, make sure that you get, absolute permission to use everything that you're ever going to ever use. It always goes to risk factors. And you may be an individual who has a very high tolerance for risk. And therefore you are willing to not know where certain information is coming from, use sort of generative AI and be perfectly comfortable with it. You are aware of the industry that you work in, you are aware of the risks that are inherent in that industry. You should trust your gut. And that's why I think it's important to, kind of moderate, say that there's a real potential that any of these either contractual or intellectual property based legal things could arise. But I think you have to do an assessment. Is it possible that it's going to arise? And am I comfortable with the risk that it could arise? And so, I think again, going to that upstream thing, if I was being extraordinarily conservative in my risk assessment, I might say, I don't want to use generative AI because I don't know where this stuff is coming from. And I have no representations from the entity that is creating it that it's legit, or it's been, that they've already obtained all the rights and privileges from the proper owners. That's the super conservative end of the spectrum. The other end of the spectrum is I don't care. I will use anything that I can get my hands on, and I'll hold my breath to see if somebody comes after me. Okay, that's fine too. And it might be that you never have anyone come after you. But there's probably something in the middle there about you mixing generative AI developed stuff or mixing stuff that you get from deep learning and manipulating it in a way so that it does become essentially a new product or a new thing that is not necessarily trackable back to any other thing. But, I think we're going to see a bunch of cases on this issue in the next couple of years. And I don't think they'll all come out the same way.
Yeah. Well, speaking as an example of that, your point about that, whether it's OpenAI or Anthropic or whoever, they're not representing that what comes out of this
Right.
is not protected. They're not saying it either way. And
Right.
as someone who's spent a lot of time, both of us, with CSI, one of CSI's big copyrighted bits of IP is master format. And if you went into ChatGPT and said, "Give me the master format for XYZ," it probably won't give you the same quality of a downloaded PDF. It's just not so good at that level of bulleted detail, but
Right.
it's going to give you copyrighted material for sure. I know
Right.
because I've done it.
Right.
And I wonder if just advice for folks on the call or that are listening to this later is make folks aware of the fact that if you're searching for something that you kind of know is copyrighted, know that it's not a valid source. This isn't a way around a license. So just understand if it's likely to be copyrighted material. Sure, you can use ChatGPT to understand it and do something and look at it and so on. But if you're going to then turn around and publish something or somehow make money on it, you're going to want to make sure that you're covered.
I think that's a great way of putting it, Hugh. And I was going to make that note that if I needed to do just a quick reference to some, part of master format or Omniclass or something like that, I would just say, okay. But if that was just for my use, for my desktop use here, and possibly to help me create some specifications for an upcoming project, it's probably fine, for that. But if I'm going to come up with some brand new specifications, four-cornered guide, that's a different issue. Or if I'm going to try to, for example, I'm going to try to teach a particular type of specification or a specification certification, it becomes more, you're going to be using a larger and larger portion of something in probably a commercial way. So again, you're starting to slide toward that. It's just an easier idea to get either permission or a license from the owner, So it's a kind of a gut check, really. And I think the listeners are probably pretty good at this kind of stuff already, and they know how much risk they're willing to take.
That kind of got us to where I was going, where I wanted to end us, is ownership of derivative data. And I think it boils down to a conversation we've had already, which is, it's really, especially in this new world where you can make derivatives of derivatives and it can kind of spin you in circles, is to ask yourself, what are we going to need this for down the road or immediately? Are we going to create our own models? Are we going to make our internal software better? Are we this? Or is our software company? Here's another one that comes up a lot is contractors have gotten, excuse me, a little bit bored of giving a bunch of data to a software company who then creates something really valuable, and they see a note that they raised, $20 million. So I think a lot of this comes back down to defining things contractually and thinking about what level of that stack of rights am I grabbing? Do I care about the underlying content? Probably not, and the person who produced it does. But do I care about how it got used? Maybe. Do I care about how the use of it got used? Like the software that used it, how does that get used? Like, I don't think anybody who, like whether it's a contractor or whoever, is going to say, I need to own the analytics, the user analytics for someone's software like that. And no one, I've never seen a contract where that isn't spelled out and carved out, where it's, we're going to own UI data so that we can make our product better.
Yeah. But I like that idea, though, that you brought up the scenario where someone goes and makes a bazillion dollars off of something that they gained as a result of the relationship that they had with you. That goes again back to the sort of early assessment as you're creating a contract. What do we want to avoid, or what would make us mad, or what would be a really horrible thing to have happen? And if someone says, "Hey, I don't want anybody to make $1 billion off of what they learned from me," well, that's something that you got to kind of think about. You could handle that in terms of they can't use anything after the relationship is over. You could do something like, if you create a derivative work based on this, we get a percentage. There's all kinds of ways you can deal with it. If it's a discomfort to you going into the relationship, manage the discomfort. Either eliminate it by walking away from the relationship, or eliminate it inside the contract, or manage it in a way that is going to be less painful to you.
Well, and one of the ways, there's two ways I know I've heard of people deal with that. I'm just going to stop here for a sec because I think this one is important. One of them, and it really speaks to how much value is what you're giving to somebody. Like, that's another problem sometimes, is it can seem really valuable to you, but you're just part of a really big pie that the other party is contemplating. And I think there's almost two paths. One of them is you can say, I want ownership or claim on all of what you do, Mr. Counterparty. Or you might say, hey, I want a better share of what we do together. And that can show up as saying, I want 5% of your company or your revenue, which is kind of option one, and really hard to get because these are usually venture funded companies who can't have that kind of term lying around. It just really hamstrings them later. The
Right.
other one is to say, I intend to do business with you, for as long as you want to. So we'll give you a discount, and maybe the discount is linked to some other thing. There's a thing called most favored nation, where you're saying, hey, we'll do 10% off of what everybody else gets, or something like that. But the point is, it's much more likely, and ultimately that's a lot of what you care about, is I want my business to benefit from what I've given you.
Yep.
I don't need, even though I'd love to, I don't need to claim an ownership of all of what you ever do, because you're going to continue growing and building new products. And how am I going to know which of those new products really was, benefited from what I gave you? The immediate one, I'll understand that, but in 5 years, will I know? Whereas a discount is a lot easier to track and just keep an eye on.
Yeah, exactly. I mean, it goes back to the sort of everything is negotiable, and that's true. If you introduce that into discussions before getting the contract draft finished, and that becomes a real issue, it might tell you a little bit about what that long-term relationship is going to be. So you may either walk away from the relationship, or you might have to moderate what you're going to write into the contract. I'm not suggesting that contracts solve everything, but they do solve an awful lot of stuff, and they don't have to be 7,000 pages long or written in garbage legalese. They should be as clear as possible and as brief as possible, but they should cover all the risks that both parties are really concerned about by entering into the relationship.
This is a really good place for us to stop. We're almost at the top of the allotted hour. Are there any questions from the audience, or anyone who'd like to kind of dive into anything deeper? You can unmute if you want at this point. Okay. Well, tell you what, guys. First of all, Paul, thank you so much for this. As ever, really, really love digging into it. I think there were some great questions along the way and really good first look and sort of defining a lot of the framework of what's going on. So thank you for doing this. Oh, hang on. Looks like we have a question. Oh, nope. People just saying nice things. Anyway, Paul, thank you again. This is great.
Absolutely, absolutely, Hugh. And if anyone has any other questions, I'm around, and Hugh can put up a note to my website or anything like that. So,
Yep.
real pleasure. Good luck, everyone.